like to thank the organizers and the leadership of this forum for an opportunity to have this briefing. The topic is key issues in supporting financial transactions in the period of turbulence. We have a number of known experts in this field: Sergei Kuznetsov, Igor Krasnov, representing him from Vneshekonombank, Natalia Kurbanalieva from the transport assets from the big transportation holding, Alexander Masyagin, deputy head from Commerzbank, Igor Dubov, my partner, and the head of the court proceedings support department of our legal group. We have a number of topics to discuss today. The changes in the civil code in terms of credit obligations, procedural changes in bankruptcies and who won, the legal basis for the restructuring of credit organizations, novelties in the federal law on consumer credits, and the potential actors in the market, latest changes in the legislation. Free discussion among the participants that will, if we have those who would want to participate in this discussion. So what is it that I can tell you as a lawyer? I don't know if you agree with that, but the financial turbulence brings work to lawyers. And usually it is the best paid work because settlements, interventions in economic activities, this is what is being paid for mostly in terms of legal assistance, in terms of legal services. So I would like to urge all the actors in the market, especially those who work in structures that are different from mine, who do not specialize. But just like in medicine, in legal matters, prevention is cheaper. So if you expect something, you have to find an expert who spends his or her days in court. And asking for a consultation will be cheaper than later going to court. And our experience proves that this is exactly like that. So whatever we think about the financial turbulence, such turbulences have become a regular matter. Our experience shows that the market actors make the same mistakes every time there's a crisis. The reasons are simple. Not enough attention is paid to closing the deals, even in the best of times. No forecast, no analysis, ready for the crisis situation. So let's not dwell on the details. Let's move on to the first issue. And I would like to give the floor now to Igor Krasnov. Please, the floor is yours. Thank you. Thank you, colleagues. Good afternoon. I'd like to agree with the idea that in times of turbulence, the role of lawyers increases. When we started providing legal support to investment projects in the bank, we had a group of 17 people. Now, the number of people who are directly involved in this work is about 30, and the whole department comprises about 70 lawyers. This is because we have to use more and more different instruments of the civil procedures because the financial risks have increased. And this is something I would like to discuss. There's some specifics about our work, but there are common matters as well. Things that we face in our work are things that face many companies. Our specifics is that we have a special legal status. We're a state corporation, and we work under the Bank on Development and the Memorandum. There are several other legal acts that regulate our activities. But the specifics is that the projects that may be implemented by normal banks between 3 and 5 years, our horizons are longer. We at the horizon, starting with the 5 years for investment projects. And that means that we have to take into account the risks of changes in legislation. Our projects are long-term, and in 10 years, legislation may change. Considering the amounts, considering the duration of projects, the risks are high. So from the very beginning, we tried to use the legal structures and legal concepts that have not been changing for many years. We tried to use the legal systems where there are a lot of precedents. This is not something that we can say about the Russian legal system. So taking into account that a lot of deals were of complex matter and a lot of foreign companies were used, as you know, the main investor into Russian economy is Cyprus, because this is where a lot of companies are registered, and these are the companies that are in control of the majority of Russian business. So when we structured our deals, we usually selected the British law, because we knew that we would be able to get all the necessary guarantees, and we would be able to use the indemnity mechanisms. We would be able to use the set of covenants that is applicable under this law, and we knew that the court protection in the London Court of Arbitration, with the use of New York Convention, would cover most of our risks. But because of the financial turbulence, and it is demonstrated mostly in the fact that we are under sanctions now, the sectoral sanctions, and also because of our portfolio, and we have a lot of companies in the portfolio that work in the defense sector. These companies are also under sanctions, even stricter sanctions. We understand that we have to find other approaches. We are not capable of using the British law now, because if we do that, we will lose some elements of our sovereignty, and there are other difficulties that arise. British lawyers do not want to participate in the financing and the structuring of such deals, and therefore we need to look for new mechanisms. Among them is the Russian law. So we understand that even though the structures that have already been introduced or are under discussion have not been tried in court yet, there's no practice available. And so we have to be pioneers in this respect. We need to look for various possibilities, but there's no alternative. So we knew that we would have to use the Russian jurisdiction, and therefore we partnered with a number of legal companies. The government has allocated funds and changed the civil code with regard to the law of obligations. And the novelties in this law were introduced with our initiative. We took a lot of time to discuss and to explain to the government how these novelties can be applied. A lot of these novelties come from the continental law system. In fact, a lot of experts believe that we may lose some of our specifics of the Russian legislation. Nevertheless, we knew that if these norms are not changed, then there will be more and more problems with regard to large businesses moving to foreign jurisdictions. And because of the difficult situation, the decisions that could be reached in foreign courts would not be in favor of our government. So the changes have been introduced, and we now can use the indemnity mechanism and the covenants in the Russian law. We have a lot of put and call options. We have great hopes for the protection with the use of all these instruments. We don't have any practice, but we hope that together with our colleagues we would be able to develop it. So, from this point of view, Sanctions have benefited our legal system because we were able to achieve all this progress because of the external influence. Had it not been for the sanctions, all these novelties would not have been introduced because it was very difficult to prove that our imperative civil law needs to have some changes.
Thank you, Igor. I agree with everything. Even though recently there has been a lot of criticism from the industry, from potential borrowers levied at the bank, I think I understand the bank's position, because by lending money, the bank has to provide to ensure a lot of guarantees, and they know that it will be at least 6 months before they can successfully end litigation, and within that period of time, they will be in a very vulnerable position. So I think they're right. Natalia Kormenalieva will now comment in order to describe the position of major industrial borrowers. What about them? Thank you very much. I represent a large transportation group where for over a decade I have been in charge of the legal service. We have practiced various lending schemes already, and of course borrowing today is rather difficult. It has become rather difficult to negotiate with the banks, especially with those that are under sanctions. They're in a less favorable position to lend these days. So we have seen a lot of challenges in terms of structuring deals and providing security for those transactions. So therefore, the provisions of civil code that will come into effect next week will harmoniously incorporate provisions of English law relating to put and call options and other English law provisions. This is a very welcome development. We have a lot of hopes associated with this. Hopefully we will be in a better position to attract to attract good terms and to get a lot of new projects underway despite the current challenges. Negotiations for borrowing and deal structuring, regardless of the bank, is a rather difficult process involving a large set of documents. We are in a somewhat easier position in this case, but nevertheless a lot of documents such as the loan agreement and the security documents have to be signed. One important document for us is the agreement on negotiations, as well as the document governing liability of the parties for good faith conduct of negotiations. We have confronted some lesser-known banks in terms of when we had revolving loan schemes with them. Sometimes negotiations took 6 to 9 months and led us nowhere, which put on hold a number of large projects such as shipbuilding, infrastructure development projects. They had to be postponed, sometimes indefinitely, because every time we had to start negotiations from scratch with each lending facility. We're dealing with a lot of infrastructure, river terminals infrastructure, seaport infrastructure, and that kind of infrastructure requires a lot of upgrading. That's why we're in a dire need of long-term credit, access to capital, because investments in the upgrading of these fixed assets, such as berths, port terminals, seagoing vessels, those investments have a long payback period, at least 10 months. Therefore, very few banking entities, very few banks are prepared to invest in such projects. Very few are prepared to wait for a sufficiently long time. But again, going back to the new provisions of civil legislation, one interesting assurance, or rather one interesting security mechanism that makes banks more comfortable in terms of renewing agreements is the Article 356 of the Civil Code. A lot of banks have a lot of liquidity that could be used for various credit. A lot of companies have a lot of assets that can be used as surety before a number of banks. However, because of the macroeconomic changes, the cost of these security assets may vary significantly over the short and long term. We have contemplated the possibility of putting together a package of security assets that can be the subject of several credit agreements, because Russian civil legislation enables a creditor to become a manager of security assets. We think this new provision can be potentially very much demanded. The options is another interesting innovation in our legislation and potentially attractive. However, when we looked at the new provisions that were added to the Civil Code, we said that the banking community is not going to appreciate options that much, even though legally they are cool. These are quite interesting documents. However, this is not going to be very feasible on the side of banks because lending decisions take place at a certain period of time, and it cannot be deferred for a long time. A very interesting new provision that is already in Russian law is corporate law provisions. It may be known to a very few people, but a corporate agreement can also be concluded with a creditor. Initially, corporate agreements were concluded with shareholders, but we are currently developing mechanisms whereby the borrower would sign a credit agreement with the bank. And there will be certain safeguarding measures, such as non-distribution of dividends during the credit agreement term. This is a mechanism that could be used. Natalia, I'm very sorry. Natalia, very sorry, but we have to move on because the time is running out. We can continue this discussion on the side. I think Natalia has demonstrated very clearly that both borrowers and banks are looking more positively at each other.
So this way we can make this process cheaper, and this would be a way to influence the final interest rate. Alexander, do you have anything to say about this? You have 2 minutes. Good afternoon. I have a very brief comment so that we could meet the time constraints. I represent the banks, as you may have understood already. And now, with regards to the new institutions, the indemnity, the representation warranties, options, Igor just said that the adoption of these changes was facilitated by the macro political situation, but I disagree with that. These novelties, these innovations have been discussed for a long time, have been prepared before 2012 in the times of President Medvedev, and you may remember how this project emerged. So I believe we are now moving in the same trend as the European systems. If you look at the German legislation 10, 12 years ago, you will see that the trends were exactly the same. The indemnity mechanism, the warranty mechanism was exactly the same. I think I'm finished. Thank you very much, Alexander. We only have 19 minutes left, and we have only covered the first issue. So please be very brief. Alexander, what can you say about the bankruptcy, the procedural changes in terms of opening cases and bankruptcy? Who have won? Starting July 1st, new rules will be introduced, so who will win in this situation? Well, as you know, The changes were mostly introduced at the beginning of the year. And the main issue, which is being discussed by experts, is related to the following: whether it is justified to strengthen the creditors' positions. There are different opinions. There are two main positions here. One is that we should still keep the balance between the interests of different parties, because, for example, now the debtors have certain limits and cannot ask for its own manager of arbitration. Why is it that the debtor cannot have this function, cannot have this right? Whereas the credit organizations, on the other hand, could initiate the bankruptcy cases without the court decision. I think that even though I work in the bank, in this case, I think I would speak as an expert with a legal background rather than a banking employee and banking manager. I think the balance of interests is not compromised, because we have to take into account why the bankruptcy takes place. The goal usually is to clear a company of all the debts. The procedure, however, the legal procedure, and people keep saying that why is it the bankruptcy does not allow for the physical persons? Why cannot we have Chapter 11 like in the United States? Why don't we have such a procedure in place? Why cannot we reorganize? Well, let me tell you this. Our bankruptcy law is an excellent law. It's an excellent piece of legislation. It has a lot of details, and it provides for many different ways to get out of the procedure without actually having to resort to selling all of your assets. So we should not really copy what other countries may have, including the United States. It is clear that the national legislation always develops with regard to national traditions. So coming back to what I think about this situation, this innovation with regard to debtors that cannot choose a manager, I think it is a very good innovation. Those people who have ever faced the situation of bankruptcy, and I'm sure that we have such colleagues here, at the initial stage, it is practically impossible to change the bankruptcy manager, because the creditors are only being put into the register. They are in the process of getting information about the debtors. And by law, it may take up to 7 months. Sometimes it takes even longer. This is the time when the debtor starts covering up, starts taking out the assets. And I think that it is definitely a very good innovation. And it is good that the debtors cannot choose their own manager, arbitration manager. Now, with regard to the right of credit organizations to initiate bankruptcy procedures without a court's resolution, well, it is not as simple as that. There were a lot of questions that arose with regard to this provision. So why is it that this innovation was made? Why cannot we make sure that that the credit agreement should be covered by this provision? Because it turns out that the credit organization can, for example, initiate a bankruptcy when a commission was not paid on the bankruptcy contract, on the brokerage contract. And again, I don't want to go into details here. In order not to lose time, let me say this. How much time do I have? 23 seconds? Okay. The rights of the arbitration manager have been expanded, and I think it is a very good step forward. It's a good innovation. Otherwise, how can the manager work? The procedure for contesting deals has been simplified. Now it has become much simpler. And the final thing that I wanted to say, and this is a painful area, the rights of creditors with assurance, because the latest changes in 1999 said that these creditors are different from the normal creditors, because the collateral creditors need first to get some money by selling the assets, but this is not true. And the fact that the collateral creditors did not have a voice led to different abuses. I think this is a good novelty. This is a good innovation. Thank you very much, Alexander. I'd like to give the floor to Viktor Krasnov for a comment. I think I would disagree with one point. I think the creditors are always the weakest side in the bankruptcy procedure, because the creditor has given the money away. The creditor did not receive the payoff. Now the creditor needs to initiate some of the procedures that are provided for by the law, but and somehow understand how these money can be repaid, or the creditor have to take care of to uncover how the assets were taken from the accounts. What is important here, and what has not been yet mentioned, is that the debtors, when they initiate the bankruptcy, have to have 30 days to notify the creditors. And I think you may have seen situations like that when debtors registered their bankruptcy in one jurisdiction and then moved to another jurisdiction, and then you had to follow this debtor from jurisdiction to jurisdiction, trying to get some of your money back. Now we have 30 days limit, and then starting July 1st, there will be a special register, and everyone will have access to this register. It will be clear and transparent, and the creditor will know. The debtors also will know. And the debtors will know whether the creditors want to initiate the bankruptcy, and the creditors have to notify not only the debtors but also other creditors, and we will also know whether the debtor is planning to file for bankruptcy, and at least we will have information about whether or not a future deal needs to be closed. We all understand that as soon as the debtor sees that a creditor within the next 30 days will file for his bankruptcy, the main task of this debtor, if it's a debtor that is not acting in good faith, a debtor is trying to sell off the assets. I think the notifications could be used in court later on, and it could be used by other creditors to protest against the deals that may have taken place within those 30 days.
Thank you very much. Then we have Igor Dubov, who has a lot of experience with bankruptcy proceedings. I would like to highlight a couple of things here. Even though in our civil legislation the main principle is the principle of good faith, however, in reality, relationships between banks and creditors are characterized by a lot of misconduct on the part of the debtor, especially when they're facing bankruptcy. The lawmakers have finally inserted a provision whereby the debtor cannot appoint a receiver or a crisis manager, because this is a very important actor. They are responsible for taking stock of the assets. They can either encourage or discourage actions from various creditors who are trying to take control over the bankruptcy proceedings. So these are positive changes, I think. As far as the right of credit organizations to initiate bankruptcy without a court decision, I think this is also the right provision to adopt, because credit organization is not managing its own cash, but it manages cash that was attracted from depositors and other customers. Lengthy court proceedings and the establishment of reserves, decreased capital of the credit organization. So these are all the consequences constraining the bank's activities in the markets and precluding it from generating revenue. But I think that there needs to be a balance of interests at the end of the day, because sometimes bona fide creditors have to deal with banks that are not really acting in good faith. So during settlement negotiations, this new mechanism may put undue pressure on the creditor as the bank is trying to derive additional benefits. Dear colleagues, I would like to wrap up on this. In our work, we deal with a lot of bankruptcy proceedings, especially with regard to banks. And, when a bank collapses, it has a ripple effect in terms of customers' bankruptcy. One of the causes of bad faith behavior is the divestiture of assets. Unfortunately, the case law of our agencies such as the Investigative Committee and the Investigative Committee of the Ministry of Interior do not provide a reason to believe that people who intend to engage in such behavior are aware of an impending punishment. So I think this is a very good restraint that has been introduced, and hopefully fraudulent abuse will become liable, including criminally. Okay, let us now talk about mergers and acquisitions when consolidating banks and the legal framework for restructuring lending institutions. Alexei, I'm giving you the floor now. Okay, my company not only deals with cases that are related to bankruptcy, but we also have a lot of practice related to assisting corporations when they deal with the banking sector. When the crisis hit, it was frequently noticed that the M&A market in Russia is in a very weak state indeed. The market in general, I mean. But interestingly, the banking market is in a different situation from other corporate fields. Currently, Russia has about 900 lending organizations. Let me give you some statistics. 2013, we had 12 acquisitions, 1 reorganization, and 2 divestitures among lending organizations. In 2014, there were 13 mergers and acquisitions, 7 reorganizations, and 1 merger. So, given the small number of lending institutions in Russia in general, I think these numbers are quite impressive. Why is this happening? Why all these mergers and acquisitions? Well, this is primarily because of the requirements of Russian legislation, according to which currently a lending organization should have a chartered capital of at least 300 million rubles if the organization is newly created. Minimal own assets also stand at 300 million rubles. This motivates credit organizations to enter into mergers and acquisitions. The central bank's position towards tightening its controls over the quality of banks' capital also has the same rationale, and also encourages mergers and acquisitions. I've given you some statistics here. Mostly acquisitions are practiced in Russia. Why this is practiced more than mergers? Well, firstly, acquisitions occur in cases when two organizations possess the same licenses, and acquisition is easier because you don't have to file for a new license. Whereas when a merger occurs, it leads to the establishment of a new entity, and in that case, it is required to obtain a new license for the same banking operations. Another reason, very often a credit organization will acquire a non-lending organization as its subsidiary. For instance, there is a legal entity that maintains some property assets related to banking activities. It may be a leasing company, and in order to increase its capitalization as a bank, it initiates this kind of acquisition of assets. The specificity of such transactions is that the organization, the entity that's being added, should not have on its books any assets or obligations that are not in line with the requirements for banking activity. For instance, they shouldn't have any insurance businesses or any trading businesses. According to the law on banking, banks cannot engage in these activities. Unfortunately, central banks' regulations do not detail this procedure for acquisitions. Nevertheless, this is a very popular mechanism that credit organizations use in order to increase their cap. Igor, you have 1 minute left. The Russian Civil Code has been amended recently, and now, in order to initiate mergers and acquisitions, an organization doesn't formally have to document this acceptance act on the transfer of rights of responsibilities. Nevertheless, the central banks and the central anti-monopoly services regulations still contain that requirement. So the acceptance or transfer act still has to be made. The last aspect I would like to draw attention to is that when reorganization of a credit organization takes place and the value of its assets is over 29 billion rubles, a permission should be obtained from the anti-monopoly service. I think 29 billion rubles is a very ridiculous amount for lending organizations because, for instance, if two major banks are merging, we're talking about amounts that are far beyond 29 billion. These banks are not going to, by merging, they're not going to monopolize the market in any way. So I don't think this requirement by the anti-monopoly legislation should stay. I think it should be amended or liquidated. Okay, dear colleagues, thank you very much. Natalia, I apologize to you for being a very inexpert moderator because we have gone over our time and we're now asked to leave this room. We have one aspect that is still not mentioned, mainly consumer credit. However, you can certainly read the new article of the Civil Code to that effect. Thank you very much. We have to wrap up. And once again, dear colleagues, I apologize for lengthening this out.